Hello everyone. In this presentation, relevancy of judgments of courts dealt with under sections 40 to 44 of the Evidence Act will be explained. As a rule, a judgment binds only the parties with regard to that particular suit or proceeding and not persons who are not parties. The doctrine of precedent means only that the basic legal principle laid down and applied in one case by a superior court will be followed and applied to another case between different parties also if the applicable rule and factual situation are substantially identical. Even in such a case, what is applied is the reason of the first decision and not the entire judgment, and the second court has to deliver a judgment again even while it follows the principle laid down in the earlier binding precedent. The Evidence Act makes certain exceptions to the above general rule of irrelevancy of judgments on important considerations, policy, and convenience under sections 40 to 44. According to section 40, when the question is whether a court should take cognizance of a suit or hold a trial, the fact that there is a judgment, order, or decree which by law bars the court from proceeding with that case is a relevant fact. A decree is a formal expression of an adjudication which conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. An order is a formal expression of any decision of a civil court which is not a decree. A judgment contains the decree or order and also states the grounds on which the court arrived at its adjudication after the consideration of the evidence and the applicable law. Thus, section 40 provides that if in an earlier case the court has finally adjudicated a matter, that judgment will be relevant in a later case so as to bar the subsequent court from reopening the matter again. Section 40 is based on two maxims incorporating the principle of private convenience, that a person should not be vexed twice for one and the same cause, and of public policy, that it is in the best interests of peace and harmony of the state that there should be finality to litigation and that multiplicity of suits must be avoided. In civil law, res judicata, which means that when a case has been finally adjudicated by a court of competent jurisdiction, the matter cannot be reopened and re-agitated again between the same parties or their representatives in interest is the rule. This rule is incorporated in section 11 of the Civil Procedure Code. What res judicata is to civil law, autrefois convict and autrefois acquit are to criminal law, which means previously convicted and previously acquitted respectively. Thus, where a person has been tried for an offence and convicted or acquitted as the case may be finally by a court of competent jurisdiction, it is unfair to try him for the same offence all over again, as such a prosecution amounts to persecution. Section 300 Criminal Procedure Code incorporates both these principles. But where an accused is discharged or a complaint is dismissed by the court, it does not amount to acquittal after trial. Thus, for the application of section 300, the person should have been tried for an offence and convicted or acquitted for such an offence. This legal protection given to the accused is also referred to as the doctrine of double jeopardy. The idea is that an accused should not be put to the peril of trial and punishment twice for the same offence. Article 20, Clause 2 of the Constitution elevates the protection against the double jeopardy to that of a fundamental right and provides that no person shall be prosecuted and punished for the same offence more than once. While the protection provided under section 300 CRPC is for both previous acquittal as well as conviction, the protection given under Article 20 is only against punishment. While both Autrefois convict and autrefois acquit are protected as ordinary legal rights under section 300 CRPC. Autrefois convict is elevated to the position of not only a constitutional right but also a fundamental right. The maxim nemo dibe bis vexare operates as a bar between civil cases inter se and criminal cases inter se, but not between civil cases and criminal cases. Now, suppose A prosecutes B for committing adultery with his wife and B is convicted. Subsequently, A files a suit for divorce against his wife on the ground of adultery with B. Though the first is a criminal case and the second is a civil suit, the issue in both the cases is whether B committed adultery with A's wife. Nevertheless, the judgment in adultery case is not applicable to the divorce suit, and the second court has to independently arrive at its own conclusion whether A's wife committed adultery with B. So, under section 40, the judgments are relevant between the parties or their representatives. In fact, they will be conclusive because the matter could not be agitated again. The court is prevented by the judgment from taking cognizance of the suit or holding a trial. These judgments are known as judgments in personam, that is, judgments binding the parties to the dispute and their representatives. Section 41 deals with judgments in rem, which not only bind the parties and their representatives to it, but also are binding as against the whole world. Judgments in rem normally deal with the status of a person. They also confer on or take away from a person certain legal character. For example, a divorce decree is granted by the court between A and B, husband and wife. The divorce decree, which is a judgment in rem, takes away the legal character from the parties that they are husband and wife and declare to the whole world that they cease to stand in that relationship from the date of the divorce decree. Section 41 consists of two parts. The first part provides that judgments in probate, matrimonial, insolvency, and admiralty jurisdictions are relevant in cases where the existence of the status of a thing or a person conferred or taken away by said judgment is relevant. The second part makes the judgments conclusive proof of the fact that the status of the thing or of the person was conferred or taken away from the date of coming into force of the judgment. Under this section, the judgment should be a final judgment and not interlocutory order. The judgment must be that of a competent court exercising one of the four types of jurisdictions, namely probate, matrimonial, admiralty, and insolvency jurisdictions. Now, what are these jurisdictions about? Probate jurisdiction. Probate actions determine the validity of a will as a whole, whether in respect of the capacity of the person making the will or of its execution, but not the construction of terms of the will. They also determine who is entitled to letters of administration in case of intestacy. When probate or letters of administration are granted, the property would vest in the executor or administrator, whose title will be recognized from then on by all the courts in India. That is, the executor or the administrator gets a legal character, that is status. It shows the legal position of an individual in or with regard to the rest of the community. As regards a judgment of a court exercising probate jurisdiction, the executor or administrator gets a legal character because the property is deemed to vest in him. A probate judgment of a foreign court will not be a judgment in rem in an Indian court. With respect to properties in India, the will must be proven in the Indian court independently. Matrimonial jurisdiction. Matrimonial actions deal with nullity of marriage, divorce, judicial separation, and restitution of conjugal rights. When a court grants a divorce or declares that a marriage is a nullity, the legal character of an unmarried man and woman are conferred upon the man and woman respectively. or it is declared that they are entitled to such legal character. In the case of judicial separation or restitution of conjugal rights, ordinarily questions of legal character do not arise because nothing is said about their status. All that the court does is, in one case, to allow married persons to live apart, and in the other, enjoins them to live together. A divorce decree granted by a court having matrimonial jurisdiction is a judgment in rem and is regarded as conclusive proof. When a divorce decree is granted between a husband and a wife, it takes away the legal character of A and B being husband and wife and makes a declaration to the whole world that they cease to stand in that relationship. However, where a foreign divorce decree is obtained dissolving the marriage between the husband and wife, whose marriage has been solemnized in India according to Hindu rites, the marital tie between them shall remain unsnapped in India, although they may be treated as divorcees in such foreign country where the divorce decree was obtained. Coming to admiralty jurisdiction. Admiralty actions are brought not against a person but a ship or a cargo of a ship. The purpose is to enforce a lien. The plaintiff's prayer will be that the ship or cargo, if within the jurisdiction of the court, should be stopped and detained until the sum due to him is paid. For example, an action for damage by collision or otherwise to the ship or cargo, or an action of salvage in which a reward is claimed for assisting a vessel in distress, fall within admiralty jurisdiction. Insolvency jurisdiction. Insolvency jurisdiction arises in cases where a person is declared insolvent by court because his debts exceed his assets. In such a case, all the property of the insolvent of whatever kind and wherever situated, subject to a few exceptions, vests in an officer of the court known as the official assignee or official receiver. The officer's title to such property will be recognized from then on by every court in India. The section is exhaustive as to what judgments would be treated as judgments in rem. Judgments relating to adoption and legitimacy also relate to status, but they do not operate as judgments in rem as they do not fall under the four categories of section 41. They will be relevant under section 40 of the Act as res judicata and will bind the parties and their representatives. The relevancy of judgments regarding matters of public nature is provided under section 42. Judgments, orders or decrees other than those mentioned in section 41 are admissible under section 42 if they relate to matters of public nature relevant to inquiry. Such judgments, orders or decrees cannot be regarded as conclusive proof of that which they state. The general rule is that a previous judgment cannot be allowed to be given in evidence between the parties in a legal proceedings unless the judgment was between the same parties. One exception to this rule of natural justice is under section 41, under which judgments which affect the status and legal character of a person or thing are relevant and are binding against all others. Another exception to the rule is contained in section 42, which provides that even judgments which are not covered by section 41 would be relevant in suits between non-parties also if they relate to matters of public nature. For example, A sues B for trespass on his land and B asserts the existence of a public right of way over the land. On an earlier occasion, A sued C for trespass on the same land, wherein C claimed a public right of way and the court gave a judgment in C's favor. The judgment in the suit between A and C will not operate as res judicata under section 40 in the suit between A and B as the parties are different. It will not be relevant under section 41 as a judgment in rem as the matter does not relate to probate, matrimonial, admiralty and insolvency jurisdiction. But such decree cannot be regarded as conclusive proof of the alleged public right of way over A's land. The latter court can look into the earlier judgment as a relevant piece of evidence and nothing more, and he can come to an independent decision as to the existence of the right. Matters of public nature include public customs, right of way, fisheries, ferry, drawing water from a well or pond, etc., and the matter should concern the public at large. Section 43 provides that judgments, orders, or decrees other than those mentioned in sections 40, 41, and 42 are irrelevant and cannot be proved unless the existence of such judgment, order, or decree is a fact in issue or is relevant under some other provisions of this Act. Section 43 again consists of two parts and states that a judgment which is not relevant as res judicata under section 40 or as in rem under section 41 or as on matters of public nature under section 42 is irrelevant unless the existence of an earlier judgment is relevant in a subsequent case as a fact in issue or as a relevant fact under some other section of the Evidence Act. The effect of section 43 therefore is that it saves from the barring nature of its provisions judgments which may be relevant under other sections on relevancy. For example, where A is tried for murder of B, the fact that B prosecuted A for libel and that A was convicted and sentenced is relevant under section 8 as showing the motive for the fact in issue. Under section 40, the previous judgment in a civil suit may be relevant as res judicata in a later suit, and similarly, the previous judgment in a criminal case may be relevant in subsequent criminal proceedings if it amounts to double jeopardy. As a rule, judgments rendered in civil cases are irrelevant in criminal cases and vice versa, as the parties are different, the standard of proof is different, and the issues may not be identical in both the proceedings. Thus, a judgment in a civil case is as a rule irrelevant in a later criminal case and vice versa. One of the exceptions to the above rule is section 41. If a judgment comes under section 41, it operates in rem, and though judgments relating to probate, matrimonial, and insolvency jurisdictions are invariably civil, they are relevant in subsequent criminal proceedings also. Thus, if A and B are divorced in 2009 and A prosecutes C for adultery with B in 2010, C can adduce in evidence the decree granting divorce to A and B to prove that B is now a single woman and is no more A's wife. C can do this even though he was not a party to the divorce proceedings. But a judgment in a criminal case cannot, in the nature of things, come under section 41 or 42, as both those sections deal with civil matters. Section 43 says that a judgment which is not relevant under sections 40 to 42 may become relevant under some other section of the Act if its existence is a fact in issue or relevant fact. The second part of section 43 says that it is the existence of the judgment which might be relevant but not the judgment as such. The second part does not provide for relevance of even the existence of that judgment, but only permits the parties seeking to prove the existence of the judgment to look for some other section under which it might be relevant as a fact in issue or a relevant fact like motive under section 8 or a transaction under section 13. A judgment can be considered as a transaction by which the right or custom in question was created, modified, recognized, asserted, or denied, or which was inconsistent with its existence within the meaning of section 13. Now, section 44 deals with judgments without jurisdiction and obtained by fraud or collusion. According to section 44, any party to a suit or proceeding may show that any judgment, order, or decree which is relevant under sections 40, 41, and 42 and which has been proved by the adverse party has been delivered by the court which had no jurisdiction to deliver it, or that it was obtained by means of fraud or collusion. The section, in fact, provides procedure for the purpose of getting a judgment annulled. A judgment is liable to be impeached under this procedure on the grounds of want of jurisdiction, fraud, or collusion. Section 44 applies to all kinds of judgments that are civil or criminal. It applies also to judgments or decrees which are obtained by means of compromise or by default. However, the section has no application to judgments which are relevant under Section 43 for the reason that such judgments would be relevant only as a point of proof of a fact in issue or a relevant fact like motive, intention, etc., which are not likely to be affected for want of jurisdiction or otherwise under the section. It is not necessary to bring a separate suit for the purpose of getting the judgment set aside under Section 44. In the same suit in which a judgment which has been proved by the adverse party can be got set aside by showing that it was delivered by a court not competent to decide it or was obtained by means of fraud or collusion. Competency of a civil court to decide the matter before it depends upon the territorial jurisdiction of the court, the pecuniary jurisdiction of the court, and the jurisdiction of the court in relation to the subject matter. Under the Civil Procedure Code, courts exercise jurisdiction only within certain territorial limits. The hierarchy of courts under the code is based on pecuniary value of the subject matter in the dispute. Lastly, the court must have jurisdiction to deal with the subject matter. For example, a small cause court cannot deal with questions relating to immovable property. Now, so far as criminal proceedings are concerned, the Criminal Procedure Code prescribes the limits of punishment that can be awarded by different categories of criminal courts. If the Court of Assistant Sessions Judge awards the punishment of imprisonment for life, it is a case of want of jurisdiction because an Assistant Sessions Judge is not competent to award life imprisonment as punishment to a guilty person. If there is a total want of jurisdiction, the judgment is nullity. But if there is only excess of jurisdiction and if the judgment is sought to be used against him, even then he can avoid it under Section 44. There is no definition of fraud in the Act, and therefore the definition in Section 17 of the Indian Contract Act is adopted, and only Clause 2 of the section applies to the kind of fraud contemplated by Section 44. Where a fact is deliberately suppressed, then fraud has been played upon the court and the section can be invoked. On the basis of the principle that no one can take advantage of his own wrong, a stranger as well as a party who is the victim of fraud can rely upon the section, but not the person who played the fraud. Collusion arises in cases where the facts put forward as the foundation of their respective cases by the parties before the court do not in fact exist. For example, in a petition for divorce, the husband alleges adultery by the wife and the wife admits it in her written statement with an intention to facilitate the husband to get a divorce decree. As the decree is obtained by collusion between the husband and the wife, the decree can be sought to be set aside by showing that it was obtained on account of collusion and she is not involved in adultery. Persons who have actually practiced fraud or collusion against the court or entered into collusion for the purpose of obtaining the judgment are not competent to get the judgment annulled on the ground of fraud or collusion. It is only a person who is not a party to such fraud or collusion and who is affected on account of said judgment who is entitled to get the judgment set aside. This in brief is about the relevancy of judgments under sections 40 to 44 of the Evidence Act. Thank you.